This case takes a sharp turn before it even begins. What you're about to witness isn't just a routine courtroom hearing. It's a collision between truth, fear, and the consequences of decisions made under pressure. At the center of it all is Miss Graham, a defendant already on probation, now facing a new charge. But here's where things get complicated. She previously stood in this very courtroom under oath and pleaded guilty. Now, she's telling a completely different story. That raises a critical legal question. Can you take back a guilty plea if you claim it wasn't truthful? And more importantly, what happens when the court starts to doubt your credibility? But that's only half the story, because later in this same courtroom session, another defendant, Anthony Young, steps up, and his case spirals into something even more intense: a long criminal history, repeated second chances, and a judge who's clearly reached a breaking point. So here's the real question for you. When does the system stop giving chances and start delivering consequences? Stay with us, because what unfolds next is a masterclass in courtroom reality, where every word matters and every contradiction comes at a cost.
Do you also go by Green?
Yes, that's my maiden name.
Okay. And so, Ms. Graham, you were previously in court. You're on probation in cause number 23, DCCR 1828, and then there was a new offense, entered a plea of guilty in the new case, and also it looks like pleas of true in at least some of the allegations in the motion to revoke. There was no agreement. I received that pre-sentence report. Have both of you had an opportunity to review the report?
Yes, Your Honor.
State has, Judge.
Right away, the judge is laying the groundwork, and this is critical. A pre-sentence report isn't just paperwork. It's a detailed snapshot of the defendant's background, behavior, and risk factors. Judges rely heavily on this to determine sentencing or whether leniency is even appropriate. But notice something subtle here. There was no plea agreement. That means the judge has full discretion. No negotiated deal, no guaranteed outcome. Everything is on the table. That's a risky position for any defendant, especially someone already on probation. And here's where it gets interesting, because when there's no agreement, the court expects honesty above everything else. So if there's even a hint that the defendant hasn't been truthful, it can completely derail the case. So ask yourself, if you were in this position, would you stick with your original plea or risk everything by changing your story?
Are there any additions or corrections?
I reviewed it with Ms. Graham, accept responsibility in hopes of.
How so? Other than saying it when she was here last time. So here's the thing, Ms. Graham. You don't get to come in and say you plead guilty if you didn't do it. So what it looks like you told the probation officer is that you didn't do this. Is that correct?
Yeah.
So why would you have pled guilty when you were here before, when you were under oath, sworn to tell the truth? I asked you very specific questions about, did you in fact do what they charged you with? And are you pleading guilty freely and voluntarily and things like that? Why would you have done that if you didn't do it?
I think it was just a lot of fear of what would happen either way.
This is the moment everything unravels. The defendant admits she pleaded guilty out of fear, not because she actually committed the crime. And legally, that's a huge problem. Guilty pleas must be made knowingly, voluntarily, and truthfully. If any of those elements are missing, the integrity of the plea collapses. But here's the flip side. Courts don't take kindly to contradictions like this. From the judge's perspective, it raises serious concerns about credibility. If you said under oath that you were guilty, and now you're saying you're not, why should the court wish-wash you this time? And this is where things get risky. By rejecting her own plea, she's essentially choosing to face trial instead of accepting a potentially lighter outcome. That's a gamble. So what do you think? Was she genuinely scared into pleading guilty, or is this a last-minute attempt to avoid consequences?
So, well, I mean, either you did what they said you did, or you didn't. Did you do it or
I
not?
did not.
Then I'm going to reject the plea agreement. Your case will go to trial. There will not be any plea agreements accepted after this today. So we'll figure out a trial date. Ms. Holmes, you're appointed.
Yes, Your Honor.
So, Ms. Graham, Ms. Holmes obviously is appointed to represent you. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney.
I'm sorry to interrupt the court.
Sure.
Before we go any further, will the court entertain putting this case on hold just briefly? I mean, there is a video in this case. And it's my understanding is this offense was captured on video. I don't know if
Have y'all
that's
taken a
been
look at that?
pressed upon this defendant.
And you've looked at it with your client?
I have.
Okay,
Well, with that being said, just never mind.
okay. I noticed that as well, that it looks
Yes,
like at least that's the,
She came in my office, we reviewed the video.
all right, so we'll let a jury,
Yeah.
we'll let a jury decide. So the underlying offense is the same that she's on probation for. I don't want to waste time on an MTRP and then the real case, or I mean,
I prefer
typically
to
we'll
go
go
forward.
forward on the MTRP
Yeah,
if
I
it's
prefer-
one that's,
MTRP.
there's no reason not to. The case isn't more serious and won't take that long to prove up. So what I'm going to do is set this, and Ms. Holmes, because it'll be on the MTRP, I'm going to leave you on that. We'll set it for a special hearing, half a day enough?
Yes.
Think? Any issue with that? You think half a
No,
day?
that's fine.
All right, so we'll set it as quickly as we can on a hearing on that motion to revoke, and then we'll see where we get on that, and then we'll go forward with the other case, the new case, if need be at that time.
Yes.
Stay in touch with Ms. Holmes. She'll let you know when you need to be back. You need to visit with her before that court date because there will be witness testimony, and then we'll hear that motion to revoke and go from there. Obviously, I think what I will also do, based on the nature that I'm rejecting the plea agreement, I'm also going to withdraw or allow Ms. Graham to withdraw her pleas of true in that motion to revoke. And Mr. Coleman, if you can, I think that it would be best, probably cleanest, if you just brought witnesses to prove whatever you think you can.
That decision right there changes everything. By rejecting the plea, the judge is effectively saying, we're starting from scratch, and now you'll have to prove your case in front of a jury. And notice something even more serious. No more plea deals will be accepted. That door is now closed. This is a powerful reminder of how quickly things can escalate in court. What could have been resolved through a plea is now heading toward a full trial with witnesses, evidence, and much higher stakes. But the judge isn't done today, because what comes next is a completely different case, Anthony Young, and it takes a much darker turn. Unlike Miss Graham, this isn't about a single contradiction. It's about a pattern. And as you'll see, the judge is about to deliver one of the most intense breakdowns of criminal history you'll hear in a courtroom.
Yes, Judge.
Okay, all right. You're free to go. Anthony Young, sentencing. What's the agree? What have y'all? No. Y'all left this open to me. It's up to me. I'm looking at jail incident reports and history, even though it's juvenile, and no. All right, so you're Anthony Young?
No.
So, Mr. Young, you were previously in court. You entered pleas of true in a motion to revoke your probation. You're on probation for theft of a firearm. I was just looking at the old PSI and it had F2 beside it, but we're all state jail felony.
Yeah.
And so you entered pleas of true that you violated your probation, and I've also received, and we've been talking about these throughout his court appearances, some updated jail incident reports. Have you both had an opportunity to review those as well?
Yes, sir. Yes, sir.
And so this is this was an unagreed plea. There was no agreement when we were here before. I also took a look at and was able to review again that underlying offense pre-sentence report as well. If anybody has any questions, you're welcome to look at mine if you don't have your copy of that. It sounds like you guys talked at least today about an agreement for an 18-month term in the state jail, but I don't, what I've seen in this pre-sentence report update, the old pre-sentence report and the incidents that have happened since we were in court last time, I'm not going to go along with any agreement. He pled unagreed. It's going to be up to me. I'll let y'all make argument. Mr. Lewis.
Well, Judge, this was a situation, of course, he was previously on probation where he was participating in a cognitive tract of ISF when the initial incident occurred. I believe it was maybe less than a week before he was to complete the program, and he was sent back. Since then, I've been in constant contact with his parents, his mother and father.
I think he was already there. This incident happened at ISF.
ISF, yeah.
Yeah.
And he was sent back from ISF like a less than a week before he completed.
2 days before he was supposed to.
Right.
But since then, I've been in contact with his parents, Judge, and they are very supportive of him in any way. I did talk with him, so he understands that probation, of course, would not be probably the best situation for him. That's why we came to the agreement that we approached you about on the 18 months. Judge, we would still ask for the, any 18 months or close to it in order to allow him to finish cleaning out any time that the court thinks is deserving at this point, and he can move on with his life. His parents are available. His father actually lives out of town, which could be a benefit to get him out into a new situation, a new circumstance to where he can start his life over. So that's kind of where we are at this point, Judge. Ultimately, I know that decision rests with you.
Mr. Smith, anything else?
I don't think I need to argue, Judge.
There were 17 juvenile either offenses or failure to comply with the court order that ended you up in TJJD. So you've already been to juvenile prison, and you got out of juvenile prison and you commit this offense. You're certified as an adult. I give you this great opportunity to go to ISF to get the tools you need, which you should have gotten in. First one was in 2019 to 2024. You're going through, you're on delinquent court probation. You should be getting all kinds of tools that you needed through the juvenile system. You should have gotten some more at TJJD. I give you an opportunity and you get to ISF and you just can't make it through. Then you get into our jail and you're told, stop getting in trouble. And you left court on the 24th, and the first incident report was on that day. First one. After I said, don't get any more, and you went back and got one the very same day, and you've had 8 since then. You like to smoke. You like to do what you want. Like to horseplay. You like to, you're still acting, unfortunately, like a child, and you're not a child anymore. And you've been told that, and you've been given these tools. And at some point, you've got to get truly a wake-up call. And I think it's great that your parents are supporting you. You should have probably been living with your dad about 4 years ago if he's out of town. If that's what y'all are saying is helpful, then maybe sometime before the 17th time you got in trouble as a juvenile, somebody does something. And that didn't happen. You just kept doing it. So if they're there to help you, you're sure not taking advantage of it. And that's on you, not on your family. If they're trying and you just choose to go run the streets and do what you want, which is what you've been doing. You had a robbery. We're not talking about just little things, right? We've got terroristic threat, criminal trespass, running away, assault bodily injury, assault family. So your family's trying to help you and you're assaulting them. Expulsion from your school, theft, robbery, aggravated assault causing bodily injury to a family member, terroristic threat, criminal mischief, escape while you're confined. That's crazy that all happened while you were juvenile. And honestly, that the most I can do today is 2 years. Somebody needs to protect, looks like a whole lot of people from you. And that's the only thing I feel like I can do today. So I'm going to find that you entered your pleas of true, freely, and voluntarily. Find those counts true again, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of a firearm. Sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not an agreement. You have some limited rights to appeal. You can talk to Mr. Lewis about that. I'm also going to hand you a trial court a written admonishment that explains that because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you, another felony. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. And so what you do with this time, Mr. Young, is going to be up to you. It's not a lot of time. You're going to be out, you're going to be real young, and then it's going to be up to you whether or not you want to change your life or not and get the help that your family's saying that they'll give you. But if you choose not to, then it's just going to get worse and worse and worse. And you're going to spend the rest of your life in prison if you keep doing what you're doing. Does that make sense? I need you to sign this and you'll get a copy of it. And
What we just witnessed are two very different legal paths, both shaped by choices, credibility, and timing. In Ms. Graham's case, the court refused to accept a guilty plea that didn't align with her own statements, pushing her toward trial where the burden of proof will now take center stage. It's a reminder that honesty in court isn't optional, it's foundational. Then there's Anthony Young, a history filled with repeated offenses, missed opportunities, and second chances that ultimately ran out. The judge's decision to impose a 2-year sentence wasn't just about punishment, it was about protection, accountability, and drawing a line after years of escalating behavior. These cases highlight a broader truth about the justice system. It can offer opportunities for redemption, but it also demands responsibility in return. Now we want to hear from you. Do you think the judge made the right calls in both cases? Would you have handled it differently? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Mr. Lewis, y'all get the bottom 2 copies.